Okay?
Okay.
Thank you.
Thank you.
Mr. Ramos Basilio?
Judge, we need to pass on him to the very end. We'll have to call the language line.
Portuguese?
Yes, sir.
Okay, thank you. Number 5, surety bonded. Number 10, your name, please.
Connor Burke.
Mr. Burke, you're here before the court charged with resisting arrest without violence. 1, 2, 3, 4, 5, 6, 7, 8 counts of possession paraphernalia. 1 count of trafficking in controlled substance. 1 count of sale of cannabis. 1 count of possession of cannabis. Another count of trafficking in controlled substance, together with the sale of controlled substance. And you also have a 15th count, a felony charge before the court. Would you like me to appoint a lawyer for you?
No, my lawyer has requested that he be appointed. I have his number here as well, Mike Kelly out of Cocoa Village.
Okay, I'm going to go ahead and call him right now.
Would you like his number?
I have the number.
Okay.
Hello?
Mr. Kelly, good morning. How are you?
I'm well, Judge. How are you?
Good. Sorry for the delay. I have you on a speakerphone here. I have Mr. Burke standing at the podium at jail court. And Mr. Burke, are you able to hear Mr. Kelly?
Yes, sir.
All right. Mr. Burke, do you recognize Mr. Kelly as your attorney of record, sir?
Yes, sir.
All right. I'm going to go ahead at this point accept his or tennis notice of appearance. Mr. Kelly, are you representing Mr. Burke here?
I am, Judge.
I just mentioned to your client the charges, except for the count 13. I have not read that charge. Would you like me to read that charge, or are you waiving the reading of that charge?
Your Honor, I'm at a disadvantage. I have not seen any police report. They have not posted one, any police affidavit of any kind. So if you want to go ahead and read that, that's fine. I'm just kind of at a disadvantage as to what the probable cause would be for that charge.
Are you able to address the issue of probable cause as to the charges?
Well, it's very difficult not being able to look at a police report, and you know, I did it yesterday on a gentleman, but you know, we went ahead and did it because it wasn't available to me. But
these are he's got 15 separate counts. If you like, I can pass on this till tomorrow and have you join me here at Vieira Court, and you can address this in person. You'll get a copy of the report.
Tomorrow in Vieira Court?
Yes.
Let's see. I don't know if I can be available tomorrow. What time would that be?
It starts at 9 o'clock, so if you're here, if we don't have any other matters besides the first appearance docket, I'll take your case first.
Okay.
Or
I feel like it would be in his best interest for sure.
Okay.
I was just going to say the same thing. I could not have it up.
They have it. They can email you a copy if you like. I can pass on this towards the end of the docket and give you a chance to get an email copy.
Okay. Judge, are you finding probable cause on all charges?
Well, I haven't even addressed that because I just wanted to know who's representing him.
Okay, Judge.
So,
all right.
in fairness, to give you a chance to argue probable cause if there's any issues.
Okay.
So
I can, well, are you going to, after these 5 gentlemen that he has here, or 8 gentlemen that he has there, he's going to bring him around after that?
I will pass on his case till the end of the docket as soon as you're ready. So this way we're not keeping you waiting.
Thank you. I appreciate it very much, Judge.
Let me see. Who's going to provide the... they have your email address, right, Mr. Kelly?
I do not. Do you?
I'm looking for it now.
State Attorney will have your email address, Mr. Kelly. We'll send you a copy of the police report.
Fantastic.
Okay.
Thank you.
Not a problem. We'll call you shortly. Thank you.
Thank you.
Okay.
Bye-bye.
Mr. Burke, have a seat. As soon as your attorney has the reports, we'll go over that. You should have a copy of the report yourself too, right?
Yes, sir.
Read that and we'll come back to you. Thank you.
Thank you.
Number 12, surety bonded. Number 13, Collins. Good morning. Your full name?
Kelvin Collins. And good morning.
Mr. Collins, good morning. The charge, as you know, is grand theft involving a motor vehicle. This is a felony charge. Are you able to hire counsel, or should I appoint counsel for you today?
Can you appoint counsel, Judge?
He qualifies.
Yes. Office of Public Defender appointed.
Diaz? She's next, so she wants to stand right here.
So, the alleged victim is a parent.
My mother.
I know, I read it.
Okay.
At this point, what says the state has to bond? Oh, it's a theft of his mother's vehicle.
My name's on that vehicle too, Judge. I'm on that.
Is it?
Yeah.
Are you?
Yeah.
Yes, Mr. Collins.
$2,000.
2000. What says the state? I mean, what says the defense?
Judge, I'd ask for
2000.
1,000.
Okay. Mr. Collins, given the nature of the situation, at this point I'm going to set bond at 1,000 cash surety, probable cause found, court date is June 23rd, 8 o'clock, before Judge Ingram for arraignment. You understand that?
Yes, sir.
All right. Have a good morning, sir.
You too. Thank you.
Thank you. Number 15, Davis, surety bonded. Number 16, Diaz. Ms. Diaz, good morning.
Good morning.
Your full name, please.
Tabitha Marie Julius Diaz.
Ms. Diaz, you're here also as a co-defendant. The charge is home invasion robbery. And based on that, they're alleging violation of your probation. You're on probation for possession of heroin. Would you like me to appoint counsel for you?
As of right now, I think I would need to because I have a lawyer, but I'm not sure if they're able to make it in today.
Okay. Who's that? Do you have a name for that attorney?
Michael Sirocco.
Okay. I'm happy to appoint an attorney for you today, and if Mr. Scirocco files a notice of appearance, he can take over the case.
Absolutely.
Financially, could you tell me how much do you earn per month?
About like $1,400.
Any other source of income besides that $1,300, $1,400?
No.
Do you own any property of any type?
No.
Okay. At this point, I will go ahead appoint counsel for you, find you to be partially indigent. The attorney will be to Regional Complex Counsel's Office. Probable cause is found as to the charge of home invasion robbery. Court date is June 23rd, 8 o'clock, Bureau Courthouse. Since the court has found probable cause on a new charge, the court does find probable cause for Condition 5 violation of your felony probation. Ms. Diaz, given the nature of the charge, and that's the fact that you're on probation, the court cannot set bond on the violation of probation case. Bond will be set no bond, set for a violation of probation hearing, July 7th, 9 o'clock, Judge Crawford, Bureau Courthouse. Now, as far as the home invasion, the co-defendant's bond was $25,000, if I'm not mistaken. Ms. Diaz, bond will be set at $25,000 cash surety, no contact with the co-defendant or any of the prosecution witnesses. You understand that?
I'm getting bond today for $25,000.
On the new charge, but no bond on the violation of probation.
So it means I can't get out.
And that, no, until you have a violation of probation hearing on July 7th. Okay? Thank you.
All right.
Number 19, Justin Anthony, last name Estremera. Good morning, your full name, please.
Justin Anthony Estremera.
Mr. Estremera, you're here before the court charged with carrying concealed firearm and two separate felony charges. Would you like me to appoint a lawyer for you today?
Yes, please. He qualifies.
Office of Public Defender appointed.
Judge, when the court is ready, I have PC arguments on counts 2 and 3.
Yes. And with your permission, I have not read the charges. Is that acceptable?
Yes.
Go ahead, please.
Judge, as it relates to counts 2 and 3, based on the 923, it appears that he's being charged with those counts because the passenger had drugs in their possession. However, the 923 doesn't indicate that Mr. Strummer knew or even had reason to know that the passenger had possession of those items. So based on that, that would not establish probable cause as to those 2 counts.
State.
I believe that probable cause could apply to what the defendant was possessing as well in the car, the odor that the car had, and the in the back. So I think that PC applies whether the passenger is possessing narcotics or the driver is possessing drugs.
Okay. No further. Okay. Were you able to hear counsel for the state's argument?
Yes, Judge. If I can respond.
Please.
Based on what Mr. Strummer allegedly had in his possession, the firearm, merely being in possession of a loaded firearm with kids in the vehicle is not, there has to be more to it than that. Just merely being in possession of it, and I think it was in the driver's side door compartment. It doesn't even appear that it was even allegedly visible to the children. And then the alleged marijuana, the 923 indicates that they did a field test on it and it tested positive for marijuana. However, with the legalization of hemp, the field tests are not able to distinguish the difference between legalized hemp and marijuana. The 923 does not indicate that he was smoking the alleged marijuana or anything other than, I believe it was a baggie of alleged fresh marijuana, if I read that correctly.
Well, what is the scheduled bond for carrying concealed firearm? Because 500 seems to be the wrong amount. It's a felony, not a misdemeanor.
Yeah, it should be 12,000.
How long has your client resided here in Brevard County?
You can answer. 6 years.
Does he have a job?
Yes.
I don't have the schedule in front of me, but carrying concealed firearm, I believe, is a
5,000. Okay.
I'm looking at the schedule now. I don't see it as an enumerated offense, so I would think it's a third-degree felony, non-violent, at 2,000.
Okay. At this point, the court, having considered argument from both sides as to the way the charge is alleged involving grave bodily harm as to count 2 and 3.
Well, it's without.
Or without, right? So is it charged as child? Is it neglect or is it? Because it's a simple assault.
It's the exposure of risk, but it's without the harm.
On the count 1, probable cause is found. On count 1, given the nature of the charge, it's a loaded firearm. 2,000 respectfully is a low amount. Bond will be set at 10,000 cash surety. Defendant to have no possession of any firearms or ammo while this case is pending. As far as counts 2 and 3, I'm going to go ahead accept counsel's argument as to probable cause to release the defendant on his own recognizance. Defendant will have no contact with any individual under the age of 18 unless that child's parent or legal guardian is present at all times. Defendant will have no contact with the co-defendant, Mr. Ferreira. And the defendant shall reside at an approved residence at all times while this case is pending in court. So I want you to have no contact with any child unless that child's parent is present at all times. You're not to possess any firearms. Court date is June 23rd, 8 o'clock, before Judge Ingram. I set bond. With that, good luck, sir. Thank you.
Thank you.
State, Mr. Ferreira. Your full name, please.
Chris Ferreira.
Mr. Ferreira, you're the co-defendant involved in this case I just addressed. Before the court, you're charged with trafficking and controlled substance, possession with intent to sell, possession of cocaine, possession of controlled substance, use or display of a firearm, and commission of a felony. Are you able to hire a lawyer?
No, sir.
Tell me about your income per month. How much do you earn?
Nothing at this point. Not right now.
Do you own any real estate, any stocks, bonds, CDs?
No, sir.
Okay. The court will find you innocent this morning for the purposes of appointment of counsel. Appoint regional conference counsel to represent you. Court date is June 23rd, 8 o'clock before Judge Ingram. As far as the items found in his statements to law enforcement, based on all that, I do find probable cause for his arrest. What says the state on the trafficking?
On the trafficking, judge, I asked you to set that at $50,000. The others, as previously set, $5,000, $2,000, $2,000.
And what about the use of the firearm, 2,000?
Candid with the court, that probably won't be filed that way. It's
Right.
probably filed as concealed.
Okay, so 2,000. Okay. All right, sir. Bonds are hereby set as follows: count 1, 50,000; count 2, 5,000; count 3, 2,000; count 4, 2,000; count 5, 2,000. No contact with the co-defendant, please, and no contact with any child under the age of 18 unless that child's parent or legal guardian is present at all times. Are we clear?
Yes, sir.
All right, thank you, sir. Fryer? Tiffany?
Hello,
Good morning. Your full name, please?
Tiffany Fry.
Ms. Fryer, you're here charged with resisting arrest without violence, possession of less than 20 grams of marijuana, 2 counts of possession of controlled substance, and 1 count of possession of paraphernalia. Are you able to hire a lawyer?
No, sir.
She qualifies.
She qualifies. Office of Public Defender appointed.
Can I speak to my attorney real quick, sir?
Yes, yes, you may, please.
Ms. Fry.
Okay, Ms. Fryer, at this point, you've had a chance to speak to your attorney. Court date is June 23rd, 8 o'clock, via courthouse for arraignment. I do find probable cause for your arrest. Any objections to the scheduled bonds?
Nothing to say.
Not from defense.
Scheduled bond, count 1 is 500, count 2, 500, count 3, 2,000, count 4, 2,000, and count 5, 500. Ms. Fryer, good luck with this matter. Thank you.
Thank you.
State versus Gamble. Good morning, your full name?
Tobin Leon Gamble.
Mr. Gamble, you're here charged with possession of a firearm by convicted felon as alleged in the docket, grand theft of a firearm, and possession of controlled substance. As to these felonies, You're entitled to representation. Can you afford a lawyer? Should I appoint you a lawyer?
No, sir. I need one.
He qualifies.
Public defender appointed. There's no conflict of interest?
I'm looking at that. I don't see the names of any other involved individuals.
Okay. Okay, at this point, if it becomes an issue, you can always bring it to my attention.
Yes.
I will go ahead and appoint the Office of Public Defender. Arraignment date is June 23rd, 8 o'clock, via courthouse before Judge Ingram. We're dealing with a loaded firearm found underneath the passenger seat where allegedly the defendant was sitting. Probable cause found for his arrest. As to the possession of firearm by convicted felon, what says the state?
I asked for 25,000 on that count. On the theft of a firearm, I asked for 10,000. And 5,000 on controlled substance based on
At this point, anything else from the defense?
Judge, I would stipulate on counts 1 and 3. However, I would argue that there's not PC on count 2. The 923 just indicates that the gun was stolen out of Palm. Says that the gun was stolen out of Palm Bay.
Right.
And it doesn't say that he's the one that allegedly stole it. And it doesn't even give it when it was stolen.
Right. At this point, your argument is noted for the record, but there's sufficient facts here for probable cause. I'm going to go ahead and set bonds as follows: 25,000 count 1, 10,000 count 2, 5,000 count 3. Mr. Gamble, you're not to possess any firearms, ammo, while this case is pending. And obviously, if you're a convicted felon, you're not to possess any firearm whatsoever, right? Good luck with this matter. Thank you.
Thank you.
Okay, we're ready for that. So let me pass on Gilbert and Gray. We'll address the case with Mr. Burke. Okay.
Oh. He's going to get him. He went to the restroom.
Oh, he did? So let me tell. Okay.
Hello?
Mr. Kelly, I had you to speakerphone. Your client is not in the courtroom for the time being. I can keep you on the phone, if you don't mind, until he arrives.
That'd be great.
Okay. If you don't, with your everybody's permission, I'll address another case while we're waiting for Mr. Connor.
That's fine with me, Judge.
Okay.
Thank you.
You're welcome. With Mr. Burke, excuse me. Ms. Gilbert?
Gilbert.
Hi,
Good morning. Your full name, please?
Rachel Gilbert.
You're here before the court on 20 separate counts. I'm going to go ahead and read these charges to you. Count 1 is resisting arrest without violence. Count 2, possession of less than 20 grams of cannabis. Count 3, using a vehicle to transport controlled substances, illegal controlled substances. Count 4 is given the weight, trafficking in cocaine. Count 5 is possession of cocaine. Count 6 is trafficking controlled substance. Count 7 is possession of meth. Count 7 is trafficking in heroin, given the amount of the weight. Strike that, that's count 8. Count 9 is possession of heroin. Count 10 is possession of a controlled substance. Count trafficking amount. Count 11 is possession of a controlled substance. Count 12 is possession with intent to sell. Count 13 is possession of a controlled substance. Count 14 is possession with intent to sell. Count 15 is possession with intent to sell. Count 16 is possession with intent to sell. Count 17 is possession with intent to sell. Count 18 is possession of controlled substance also with intent to sell. Count 19 is possession of a controlled substance. And count 20 is possession of paraphernalia. This is an incident involving co-defendant Gray. Are you able to hire counsel?
No. Can I speak to my lawyer?
First, let me see if you qualify.
She does.
Okay. I'll go ahead and appoint counsel for the defendant, so the Office of Public Defender, pass on her case, so I'll be in the docket to address her matter. Thank you.
Have a seat, I'll come back to you.
I don't even understand.
Mr. Burke back?
Yes, sir.
All right. Mr. Burke, I have you before me. Your attorney's on the phone. Allow your attorney to speak on your behalf. Mr. Kelly, did you get a copy of the police report?
I did, Judge.
Would you like for me to read the charges, or are you waiving the reading?
Well, we can waive the reading because I see what they are.
Okay, very good. Argument as to probable cause?
Judge, I don't see probable cause on all the paraphernalia charges. I see possibly 5, maybe 4, but not 7. I don't see any probable cause for the sale of the cannabis or the sale of a controlled substance.
You don't, or you do see probable cause?
I do not. I do not.
Okay. Let's go through each count. Count 1, resisting arrest without violence. Issues with probable cause?
There is none with that.
As to counts 2 through 9, you're alleging there's not sufficient probable cause for all 8 counts?
That's correct, Judge.
Okay.
Judge,
They're not listed on the police report exactly what they are. And going through the report quickly, I try to get back to you as quick as possible because I know you're handling court as efficiently as possible. But I didn't see 8 counts of paraphernalia there.
So we have the baggie.
we got the baggies for each substance. We've got a scale. We've got there's a bag that has 96 pills in it, or tabs. There's another bag that contained 46 pills. There was a clear bag that contained green pills. Vacuum mail bag. There's a vacuum mail bag that had 102 grams of marijuana in it.
Are we counting bags that were inside other bags? Is that what we're doing?
I'm counting what's actually holding the substance, not the the Family Dollar bag. I'm not counting that. There's a scale. I mean,
It's like 4 counts.
I'm counting at least 4 on my reading, and I'm comfortable with that.
Okay. Ms. Kelly, there's at least 4 baggies that we can count based on the way this report is written.
3 and 1.
Okay.
So
I agree with that.
okay. So probable cause as to 4 counts of paraphernalia. On the remaining counts, does the state need additional time, or should I release the defendant ROR?
ROR, the remaining paraphernalia.
Okay. And on the trafficking, given the weight, any objection to probable cause on count 10?
I didn't see anything tested in the results of anything being tested. Maybe I glossed over it trying to get back to you as quick as possible. Any field testing of this, maybe I missed it, Judge, but I'm trying to find it now. Let's see here. Which field tested? Okay, so it did field test for the MDMA. Okay. The next to 10 to 200
Right.
trafficking charge. I agree. There's probable cause for that.
In the sale of cannabis?
No, sir. I don't agree to that.
State?
Probable cause.
I think it should be possession with intent to sell. Judge.
Okay. State's position is, Judge, you should find probable cause for possession with intent to sell
Because of the weight?
because of the weight and the scales.
Well, I would say maybe possession of felony cannabis, but not so much with intent to sell.
Okay.
The intent to sell, it could be that scale could have been with who knows what there.
Okay.
I don't know, Judge. But
Very well.
I would,
What about possession of cocaine?
yes, I agree to that, Judge. Probable cause for yes.
Count 13.
Contributed delinquency of a minor.
Oh, yes.
I don't see anything other than her being in the vehicle. I don't know. There's lack of probable cause there.
Okay. And then count 14, trafficking, and count 15, sale.
14, I agree. Probable cause. 15, no probable cause.
In the state's position on 15, that should also be possession with intent. Okay. All right. All right, Mr. Burke, let me go ahead. I've heard argument from both sides. Let me go ahead and make some findings on the record. As to count 1, resisting arrest, probable cause found. As to count 2, 3, 4, and 5. Probable cause found for each of the possession paraphernalias. On the remaining paraphernalia charges, you'll be released on your own recognizance since there's not sufficient articulation of facts for me to define probable cause as to those paraphernalias. As to count 10, trafficking, I do find probable cause. As to count 11, I do find probable cause as to the charge of possession with intent to sell cannabis as opposed to sale of cannabis. As to count 12, I do find probable cause as to possession of cocaine. As to count 13, given the way the charge is stated under 827.041, over your attorney's objection, I do find probable cause. As to count 14, probable cause is found. And as to count 15, the court will find probable cause as to the charge of possession with intent in lieu of sale of a controlled substance. Bond-wise, what says the state?
Judge, count 1, $500. Count 2 through 5, I think is where we ended.
6, yeah.
6, $500 apiece. Count 10, trafficking in MDMA, 10 grams or more, but less than 200. I asked you to set that at $5,000. Possession of marijuana with intent to sell, $5,000. Possession of cocaine, $2,000. Contributing, $500. Trafficking in LSD, I asked you to set that at $50,000. Sale or possession with intent to sell the Xanax, I'd ask you to set that at $10,000.
Okay, Mr. Kelly.
Your Honor, my client does not have that kind of money. This 21-year-old man who has lost his job basically just as the coronavirus hit. He's basically just trying to survive. If we leave him in the jail there with that kind of a bond, he's never going to be able to make that. And then trying to get a bond hearing, I have had lots of, I don't know how to put it, it's been very difficult to get any kind of hearing quickly. But $75,000 and $50,000, it's just way above, what he could pay. He doesn't even have a job at the time. So obviously he's been trying, but this is not the time to find jobs, obviously.
Right.
If we could reduce that down to something more reasonable, we would greatly appreciate it, Judge.
And your suggestion is how much is reasonable?
Well, what is the scheduled bond schedule call for? I don't have that in front of me, but I would assume it's quite a bit less than that.
Okay. State anything else?
Judge, just he was out on bond for aggravated assault with a deadly weapon ×4 and 20 CF 26598. So that's the reason why I'm requesting the high bond.
Mr. Kelly, he's out on bond on a felony case, so at this point, since I'm not revoking that bond and housing him on no bond, it's probably best to set a sufficient surety here. And I do appreciate your argument here, but given the nature of the charges and the amount of narcotics involved, the court will set bond as follows. On count 1, resisting, $500. On count 2, 3, 4, and 5, my apologies state it wasn't count 6, it was up to 5. Bond is $500 per count. On count 6 through 9, the defendant will be released on his own recognizance. on the charge of trafficking and controlled substance, given the weight of less than 200 grams. Bond is set at $75,000. On count 11, possession with intent to sell, bond will remain at $5,000. On count 12, possession of cocaine, bond is $2,000. On count 13, bond will remain at $500. On count 14, trafficking in illegal substance, bond will be set at $50,000. And on count 15, possession with intent to sell, bond will be set at $5,000. Court date June 23rd, 8 o'clock, Judge Ingram, Vieira Courthouse. The defendant shall not possess any firearms or ammo while this case is pending before the courts. Thank you, Mr. Burke.
Thank you, Judge.
Mr. Kelly, I appreciate your patience with the court. You have a good morning and enjoy the rest of your day, sir. Thank you.
Thank you. Have a great weekend, Judge. Take care.
Thank you.
You too, State.
Thank you.
Mr. Gray.
Yes, sir.
How are you, Mr. Gray?
I'm doing all right.
Mr. Gray, can I have your full name?
Antoine Gray.
Mr. Gray, you're here before the court on 25 separate counts. Let me go ahead and read these charges to you. Count 1, resisting arrest without violence. Counts 2 and 3, possession of firearm by convicted felon. Count 4, possession of drug paraphernalia. Count 5, possession of ammo by convicted felon. Count 6, possession of ammo by convicted felon. Count 7, possession of ammo by convicted felon. Strike that. That's count 6. Count 7, possession of a concealed weapon by convicted felon. Count 8, possession of a concealed weapon by convicted felon. Count 9, possession of cocaine. Count 10, trafficking in cocaine less than 200 grams but over 28 grams. Count 11, possession of cocaine with intent to sell. Count 12, possession of meth with intent to sell. Count 13, possession of meth. Count 14, possession of meth. Trafficking weight over 28 grams but less than 200 grams. Count 15, trafficking heroin, possession amount over 4 grams but less than 14 grams. Count 16, possession of heroin. Count 17, possession with intent to sell heroin. Count 18 is possession less than 20 grams of marijuana or cannabis. Count 19, possession of meth over 28 grams but less than 200 grams. Count 20, possession of meth of a controlled substance with intent to sell. Count 21, possession of controlled substance. Count 22, possession of controlled substance with intent to sell. Count 23, possession of controlled substance. Count 24, possession of a controlled substance. And count 25, possession of controlled substance with intent to sell. Co-defendant Rachel Gilbert. At this point, would you like me to appoint counsel for you, Mr. Gray?
Yes, sir.
He qualifies.
Regional Conflicts Counsel will be appointed for Mr. Gray. Since his attorney is not here, if Ms. Gilbert's counsel wishes to address the court as a friend of the court, I would consider any argument. State as to the possession of firearm by convicted felon, 2 counts, possession of ammo, 2 counts. What says the state? Any issues?
The ammo is in the gun, Judge, so the reality is we only charge for the firearms.
Right. So isn't that how, I think based on case law, shouldn't that be just
how it should be?
Okay. So, and what about the possession of concealed weapon by convicted felon?
I think that's duplicative of the firearm.
Okay.
Well, I think
Let me see.
it was they were next to the seat by the seatbelt. He could be charged with concealed firearm and firearm by felon.
Okay. Okay. Very well. Any other issues from the state's point of view?
Not from the state's point of view.
Okay. Mr. Gray, at this point, I don't want you to say anything about the case. This is very serious charges you're facing. So at this point, the court does find probable cause on the majority of the charges before me. Let me go through each count, and I'm going to hear from the state, and I'm going to hear from you as to the amount of bond. Count 1, probable cause found as to resisting arrest without violence, 500 acceptable.
Yes.
Count 2, possession of a firearm by convicted felon. What says the state?
That's for $20,000.
Count 3, possession of firearm by convicted felon.
That's for $20,000.
Count 4, possession of paraphernalia, 500 acceptable.
Yes, sir.
Count 5 and 6, possession of ammo. Any objection, ROR? Okay. Count 7, possession of concealed weapon by a convicted felon.
Good. 2,000
Per count.
per count.
Okay. Possession of cocaine, 2,000 acceptable. Trafficking, count 10.
50,000.
Count 11, 5,000 acceptable. Count 12, 5,000 acceptable. Count 13, 2,000 acceptable. Count 14, trafficking.
This is the trafficking in meth, correct?
Meth, yes.
50,000.
And then trafficking in count 15 of heroin.
75,000.
Possession of heroin, 2,000 acceptable.
Yes.
Possession of heroin with intent to sell, 5,000 acceptable.
Yes, sir.
Cannabis less than 20 grams, 500 acceptable.
Yes, sir.
Trafficking also looks like
This is
the amphetamine. Count 19.
50,000.
In count 20, 5,000 acceptable.
Yes, sir.
Okay. And the remaining counts acceptable as listed.
Those are all simple possessions, correct?
Right.
Yes, as listed.
Okay. Well, there's some that's possession with intent to sell. Those are 5,000.
Which one was that?
Number 20, number 22, and number 25.
They're blacked out on the 923, so I was just trying to see what it was. 22.
20,
Yes, that's one.
it's 5,000. Okay. Mr. Gray, court date June 23rd, 8 o'clock, your courthouse for arraignment. Count 1 is bond set at 500. Count 2, 20,000. Count 3, 20,000. Count 4 is 500. Count 5 and 6 you'll be released on your own recognizance since there's no finding of probable cause. As to count 7, bond is 2,000. Count 8, bond is 2,000. Count 9, bond is 2,000. Count 10, bond is 50,000. Count 11, bond is 5,000. Count 12, bond is 5,000. Count 13, bond is 2,000. Count 14, trafficking, bond is 50,000. Count 15, trafficking, bond is 75,000. Count 16, possession of a controlled substance, 2,000. Count 17, possession with intent to sell, 5,000. Count 18, possession less than 20 grams of cannabis, 500. Count 19, trafficking controlled substance, 50,000. Count 20, possession with intent to sell, 5,000. Count 21, possession is 2,000. Count 22, possession with intent to sell, 5,000. Count 23, possession of a controlled substance, 2,000. Count 24, possession of controlled substance, 2,000. And count 25, possession with intent to sell, 5,000. No contact with the co-defendant, Rachel Gilbert. No possession of any weapons or firearms or ammo. Thank you.
I have no contact with my wife.
Michael Quinn.
Good morning, Your Honor.
Good morning, Mr. Quinn. Your full name, please? Your name?
Michael Pogulin.
You're here because of a charge of driving on a suspended license as a third offense. It's a felony. Bond is 2,000. Why haven't you posted your bond?
I don't have any family here, Your Honor. All my family lives in Orlando. Both my parents are older. They live on a fixed income.
I appreciate that. At this point, do you want me to appoint counsel for you?
Yes, please.
He qualifies.
He's Office of Public Defender appointed for Mr. Quinn. 2,000 acceptable to both sides.
With the city, that's fine.
Defense, 2,000.
Yes.
Bond is set at 2,000 cash surety, no driving unless you have a valid Florida license or a hardship license. You understand that?
Yes, sir.
Court date June 23rd, 8 o'clock, Judge Ingram for arraignment.
Yes, sir.
Vieira.
Thank you.
Thank you. Good luck. Thank you. Mr. Hammond? Mr. Hammond, good morning.
Good morning, Your Honor.
Your full name, please?
Nathan Alexander Hammond II.
You're here before the court charged with fourth offense DUI, refusal to submit to a breath, blood, or urine test, having previously refused such a test, 2 counts of possession of controlled substance, driving while license suspended, with knowledge, third offense, and possession of paraphernalia. Are you able to hire counsel?
I am, depending on how long I'm here. If I get bond, I could post out and hire counsel, sir.
Is he on probation? I don't see an on-site, but it looks like he's on probation for giving false information to a pawn shop.
I didn't see that, Judge.
My wife is standing by now to postpone for me to hire an attorney now, sir.
So you don't want me to appoint you a lawyer, Mr. Hammond?
No, but as long as I can bond, I'll hire my own attorney, sir. I think it was only a few of these charges I didn't have bond.
Okay. PTR shows on family probation.
He pled August 19th, 2019, 36 months of service.
He's not gonna, you're sure he bonded. You're sure he bonded. So bonded.
He bonded to get a POP after.
Oh, sorry.
So that he has an aggravated assault in his history, so I asked that you on-site it now and pull him over on stuff.
Mr. Hammond, given the fact that you're on probation for giving false verification to a pawn shop, you're placed on probation August of 2019. The probation is to last through August of 2022. The court has the discretion to impose an on-site violation in your probation.
Your Honor, as much as I would love to pray to you, sir, we just got a home and I'm working 47 hours. I am the breadwinner. I haven't been in trouble in quite some time. I'm doing very well. Very, very well, actually. I just need to get home to continue paying my bills, sir, and take care of my family.
I understand. It's the issue is there's a previous aggravated assault charge that may qualify for AMA, right? Is that what they say? So that's the issue. Mr. Hammond, at this point, do you want me to appoint a lawyer for you today?
I mean, I could afford one if I know I'm going home, sir. That's the only thing.
Let me explain it to you,
yes, sir.
Kind of so you know. Even if I take no action today instead of bond, before you're able to post a bond, the jail will look at this charge and basically have you brought before the court, because they're not going to release you when you're on felony probation, especially when the state says, Judge, he may be AMA. So you'll be seen either tomorrow or hopefully tomorrow on an on-site violation of probation. And if the court finds that you're AMA, the bonds you've posted would be no good. At that point, you'll be housed no bond pending a trial. That's the issue.
Right. And
so,
the only, is there, I'm sorry to waste so much time with the court. Is there a time frame on an AMA before before you don't have a violent crime that the AMA does not pertain to you, or is that a lifetime?
I can't give you legal advice. That's probably best asked to an attorney. That's why I'm asking you. Do you want me to appoint a lawyer to address those issues under that attorney-client conversation?
Could I just ask what year the AMA charge was from?
2007.
2007.
2007. No, you don't have to appoint an attorney.
No?
No.
Okay. Okay. At this point, the court, given the facts before the court in my review of his score sheet that was filed in open court on August 19th, 2019, I'm going to go ahead, use my discretion, and impose an on-site violation of probation. Having found probable cause as to new charges, the court will find probable cause for an on-site violation of his felony probation. What says the state as to the new charge?
On the new charge, Judge, I'd ask that you set on fourth offense DUI at $5,000.
And refusal?
1,000.
And the possession of controlled substances?
2,000.
And the possession, third offense, driving on a suspended? 2,000. And a possession paraphernalia? 5,000. Okay. To the clerk of the court, the case number that y'all need is 2018 CF 43816 for the on-site. As to the new charges, bond on count 1 is 5,000, count 2 1,000, count 3 2,000, count 4 2,000, count 5 2,000, count 6 500. Mr. Hammond, your court date is June 23rd, 8 o'clock before Judge Ingram on the new case. On the on-site case, that matter will be set for a violation of probation hearing before Judge Maul. When does the judge set those?
Your Honor, then
that would be July 7th at 8:30.
We might as well have just got me counsel then, Your Honor, because if I'm not working, I will not be able to hire an attorney. So I will be sitting here, and I'm not going to be able to afford one.
Okay. I will honor your request, and I assume he qualifies.
Yes, he does.
I'll go ahead and appoint counsel for Mr. Hammond on both matters. Any additional argument, counsel, as to the issue of AMA?
No argument.
All right, on the on-site violation of probation, you'll be housed on no bond pending a violation of probation hearing July 7th, 8:30 before Judge Maul. Good luck with both matters, Mr. Hammond. Thank you, sir.
Yeah,
Judge, and I missed the bonds on the new case.
Oh, sure. 5,000 count 1, 1,000 count 2, 2,000 count 3, 2,000 count 4, 2,000 count 5, and 500 count 6.
Thank you.
Thank you. Mr. Howard?
Your Honor, Mr. Howard was a surety bond.
Oh, thank you. Mr. Johnson?
Good morning.
Good morning, Ms. Johnson.
How you doing?
How many kids you're supporting?
Right now, 3, but I don't even know what's going on right now.
Well, I'm going to give you a chance to show up and address this in court without you sitting in jail today.
Okay.
So I'm going to go ahead and release you per the administrative order on your own recognizance. Make sure you show up on June 15th at 1:10 in the afternoon, Melbourne Courthouse, before the hearing officer.
Okay, well, can you give me a second so I can write this down, because, like I said, all this is confusing to me right now.
It's a child support issue. They're going to provide you the paperwork, and the court date and time will be in writing for you.
Okay, well, thank you.
Okay. If you change your address, notify the clerk's office, please.
No, my address still is. See, I've been gone in Pennsylvania. I'm just not coming back 3 months ago. But I've been paying my child support. But I'm just now getting my job at Flawless like 3 weeks ago. So.
Well, that's what I'm saying. When you get out, go to the clerk's office, call them first to see if you can go to the clerk's office.
Okay.
Give them an updated address, so this way, if there's a change of court dates or court event, they can notify you.
Okay.
Okay? Have a good morning. You're getting out today. Thank you.
Thank you.
And Your Honor, Mr. McLean was just a surety bond.
Thank you. Which brings us to Mr. McRae.
Mr. McRae. McRae.
McRae, good morning. Your full name?
Scotty Arthur McRae.
2 charges, both are violation of probation. You're here before the court in 2 separate felony violation of probation cases. You had a court-appointed counsel previously. Do you want me to reappoint them?
And I hadn't yet moved, so I don't know how I got a violation because I was still living with my wife and we were fighting. So she said that I had already moved, which I didn't.
Okay, I'm just asking you, do you want me to appoint you a lawyer again?
Oh, yes, sir. I'm sorry. I misunderstood you.
No, you're fine. Any objection to the public defender's office representing the defendant on both matters?
No, Judge, he qualifies.
Office of Public Defender appointed on both matters. Is there any special designations?
There's not.
Okay. Now, your next court date is going to come up in a couple of weeks, so you can address this with Judge McKibben. But right now, as you can see, it's no bond. Your court date is set for arraignment, June 11th, 9 o'clock at your courthouse, before Judge McKibben on both. As the case, can we set both cases before one judge, or should it go before 2 judges? With all the
They should stay where they are.
different judges? Okay. 2019 CF 44856, you'll see Judge McKibben June 11th at 9 o'clock. 2019 CF 49666, you'll see Judge Ballou July 27th, 9 o'clock, right at the courthouse. All right. Thank you, sir.
I get a bond or not?
There's no bond on both matters, sir.
I'm taking care of my family. I've got to be out to take care of them through my Social Security. Plus, my dog he's sitting at a different place there. When they arrested me, now he's sitting with this dude that I don't even know. My dog is.
Well, I think you can address that, file a bond modification before the appropriate judges, but for today's purposes, they don't want me to set bond. So,
oh, my
thank
Lord.
you.
Here, take my dog away.
Mr. McElhaney?
Yes, sir.
Your full name, please?
Bernard Ashby McElhaney.
Are you here on a charge of misdemeanor battery, given the relationship with the alleged victim? It's
My wife.
Domestic violence? Yes. Are you able to hire an attorney to help you with this case?
No, I'm not, but
He qualifies.
Office of Public Defender appointed. Now, does he have a place to reside away from his spouse?
yes, I do.
Okay. State's position?
Court's discretion on this one. I've had no contact with the victim.
What is the defense's recommendation?
Judge, we would seek pretrial release. I see no prior violent convictions on his history.
Is your client working still, right? I mean, how long has he lived here in Brevard County?
Yes, sir.
How long have you lived here?
Excuse me?
How long have you lived in Brevard County?
I've lived in Brevard County 12 years.
All right. And you need to provide that address as to your new address to pretrial release. I'm going to go ahead and release you on pretrial release today.
Yes, sir.
No contact with your spouse, please, while this case is pending. You're permitted one time with law enforcement to go there and pick up your personal effects.
Okay.
Are you willing to abide by these conditions?
Yes, sir, but am I getting like evicted from my house? I've lived there 12 years.
Until this case is fully resolved in court, it's best for you not to go back to your house. It's not an eviction, it's just a request.
Right. Okay, I understand, sir.
It's a request, which is a requirement. It's an order of the court. It's not an eviction.
Yes,
but
sir.
if you go back there, you'll be back here on a new charge. If you contact her, you'll be back here on a new criminal charge.
Okay, as far as contacting her, like over the phone or anything?
No phone calls, no emails, nothing.
Yes, sir. Now I understand.
Okay? And you're permitted only one time to go back to your house to pick up your personal effects with law enforcement.
Yes, sir.
Are you willing to abide by these conditions?
Yes, sir.
Are these conditions acceptable to the state?
Yes, sir.
Acceptable to the defense?
Yes, Judge.
July 7th, 9 o'clock, Judge Babb for arraignment. So good luck with this matter, sir. Thank you.
Thank you.
Judge, I'm sorry, can we readdress Mr. Hammond? Was he,
Mr. Hammond.
right, he was the on-site, was he AMA?
Yes, he is AMA, so we need to get it a violation probation hearing date.
Okay, that would be July 7th at 8:30.
For record purposes, he has an aggravated assault from 2007 that he was convicted of here in Brevard County. Thank you.
Thank you. Ms. Mitchell, good afternoon.
Good afternoon, Judge.
Your full name, please.
Amber Ray Mitchell.
Did you get a copy of the police report?
Yes, sir.
Right. Several charges, 4 felonies, 1 misdemeanor. Do you want me to appoint a lawyer for you on these drug charges?
I'm not sure that I'll have one yet. I guess just do, if we can do coin appointed for now, and I'll go from there. If that's okay.
Say that again, please.
I'm not sure that I have one right now. I haven't talked to them yet, so do court appointed, please, for Judge.
Okay, I will appoint. Sure. Well, she's qualifies?
Yes, yes, she does.
All right, Public Defender's Office appointed. Court date June 23rd, 8 o'clock. Arraignment, Judge Ingram. State. She was apparently trying to cover for her boyfriend.
She was, Judge. She caught some charges because of it. Judge, on the paraphernalia, I'd ask you to set it at 500. On each of the possession counts, I'd ask you to set it at 1,000 each.
Okay. Any objection to reducing the bonds to 1,000 on each felony?
Judge, I would ask for pretrial release. She has no prior failures to appear, and the court can see that what the 923 is.
Now, if I do that, she's going to have to submit to random testing to make sure there's no drugs.
She's in agreement.
All right. Ms. Mitchell, I am going to, over the state's objection, exercise discretion given the fact that you cooperate with law enforcement and the facts involved here. What's the boyfriend's name?
Justin. His ex is my ex, and he overdosed Monday.
No.
Okay, he overdosed Monday. He left his stuff in my car. That's what's there. I just didn't even realize it was there. So until they were there, but it's Justin. I don't know where he's at. Okay, sorry.
I just asked for a name. So
I'm sorry. I don't know. His name's Justin.
Justin. Okay. No contact with your ex-boyfriend, Justin, right?
No.
Pre-trial release with random testing at your own expense. Court date provided. Probable cause found. Thank you.
Thank you. Thank you. Thank you.
O'Brien, number 40, surety bonded. Number 43, Perry. Mr. Perry present?
Yes, sir.
Mr. Perry, your full name?
Austin Blake Perry.
Mr. Perry, you're here on a charge of robbery pursuant to the state's attorney filing a charging document. As to this felony charge, are you able to hire a lawyer?
No.
He qualifies.
Public Defender's Office appointed. The court will enter a plea not guilty on behalf of Mr. Perry. Allow counsel 10 days to file the appropriate motions with respect to the charging documents. Set this case for docket sounding July 9th, Vieira Courthouse, 8:30, Judge Maloney. Bond is $15,000 acceptable.
Is there any way that it could be lowered a little bit? By any chance?
Not at this point, given the fact you have a failure to appear outstanding. Bond is $15,000 cash surety. Thank you. Mr. Potter?
Yes, sir.
Potter, your full name, please.
Albie Yvonne Potter, Jr.
The charge is battery by strangulation involving your girlfriend. Because of that, it's domestic violence. As to this felony, should I appoint a lawyer?
Yes, please.
He qualifies.
Thank you. Office of Public Defender appointed. Court date is June 23rd, 8 o'clock, Judge Babb, Vieira Courthouse. Has the state heard from the alleged victim at all?
I have not, Judge.
State's recommendation?
Judge, based on the prior record of domestic violence related charges in 2018, 2018, different victims. I'd actually set the bond at $7,500, no contact with the victim, no return.
Okay. Bond suggested is $7,500 acceptable?
Judge, defense would ask for $5,000, and he has no prior failures to appear.
Can he afford a GPS on his own?
How much are they?
Judge, he's indicating that he received Social Security.
Okay.
And he says it's a close call.
Okay. Bond will be set at $7,500 cash surety, no contact, direct or indirect, with the alleged victim. If you have any personal property at the location of the incident, a one-time return with law enforcement to pick up your personal effects. Good luck, Mr. Potter. Mr. Smith?
How you doing, Your Honor?
Good, Mr. Smith. Your full name, please.
Ernest J. Smith IV.
The charge is battery, domestic violence involving your ex-girlfriend, and also 2 counts of burglary of a occupied conveyance, a vehicle. Would you like me to appoint a lawyer for you?
No, sir. I gotta get a lawyer.
He's indigent?
I just don't know. I don't know.
Hang on.
No.
Judge, he indicated he has a weekly income of $1,800, and he has one dependent.
Her.
And equity in a vehicle of $5,000.
That's what I paid everything for her.
Okay. I will find it partially indigent, appoint counsel for Mr. Smith for the Office of Public Defender.
No, so there's for the burglary. I mean, I was pretty much getting out. All right, yes, sir.
I've read the report.
Yes,
I
sir.
kind of know what happened. So has the state heard from the alleged victim or the victim's mom? Okay. State's recommendation.
Judge, they come in as, I've got them in as a Burke battery and a battery DV. Battery.
It's 2 counts per battery. One involving, I guess, the mother. The other is the victim.
That's correct.
Right.
But is the first count a burglary with a battery?
Yes.
On the burglary, of the occupied premises, I'd ask for, I have them, I'm sorry, Judge.
Oh.
On my 923, I'm showing that the charges are different than what are in.
Oh, it's 2 counts of burglary occupied vehicle with battery therein.
Right, that should be an F1 PVL.
No, it goes it's a burglary of a conveyance, and then it goes up one more. Right? It's the car.
I think it's the Burke battery. It goes all the way to PVL.
PVL.
Robbery.
No, take your time.
Say again, sir.
I don't want you to talk about the case because it's very serious charges against you, so let your attorney speak for you, please.
On the battery domestic violence, I'd actually set that at $1,000. On each of the burglaries, I'd actually set them at $15,000.
Okay.
He should know that those burglaries could go up, they could go down.
Right. Defense, total bond is $31,000. Acceptable?
31,000.
Yes, Judge.
Count 1, 15. Count 2, 15. Count 3, 1,000. Probable cause found. Court date June 18th, 8 o'clock. Judge Friedland, Titusville Courthouse. No contact with your ex-girlfriend or her mom, please. Okay? No possession of any weapons, firearms, or ammo while this case is pending. Thank you. Mr. Williams, present?
Yes, sir.
Mr. Williams, your full name, please.
Marcel Williams.
You're charged here before the court. Strike that. The reason you're here before the court is your bondsman has decided to go off your bond.
No.
You can either post the previous bonds of $2,500, strike that, previous bonds of $3,000, or wait for a bond modification. Court date is June 9th, 8 o'clock, arraignment. That's been canceled.
No,
Mr. Williams, do you have a lawyer?
No, sir. And I want to say something. The bondsman didn't come off of it. I surrendered the bond. So
I saw that. You told him to take you to jail, so you wanted to get off the bond. So
Right.
I read that.
Okay.
Now, do you want me to appoint you a lawyer today?
No, sir.
You sure? Because your next court date is not till June 23rd now.
All right.
June 23rd, 8 o'clock, early resolution, Judge Babb. And you sure you don't want a lawyer?
Positive.
All right. Good luck with this.
All right.
State versus Yates.
Hello, Your Honor.
Good afternoon, Mr. Yates. The docket shows resisting arrest with violence and DUI. Your full name, please?
Erdel Yanez.
Giannis, Mr. Giannis. Do you want me to appoint a lawyer, Mr. Giannis, for you?
Yes, please.
He qualifies.
He's in it. Office of Public Defender appointed. I put a little question mark as to count one, resisting with. State and defense, any argument?
Judge, from the state point of view, he was walking, he struck the officer identified himself, and he struck the officer.
Should that be more battery on a police officer than resisting?
He's offering the violence, it's a closed fist punch. Both.
Okay.
Resisting is actually a higher scoring offense.
Is it? Okay. Defense, did you hear that?
Yes, Judge. I have no argument.
Okay. I'll go ahead and find probable cause as to both counts. Scheduled bond is set 2,000 count 1, 500 count 2. Acceptable?
Yes,
defense?
acceptable.
Okay. Court date is scheduled for June 23rd, 8 o'clock, your courthouse, Judge Babb. At this point, no driving unless you have a valid Florida driver's license. Anything else from either side?
No,
Mr. Giannis, you have a good afternoon, sir. Thank you.
Judge, can we readdress Amber Mitchell?
Mitchell.
Yes, you released her PTR with random testing at her own expense.
Yes.
What are we testing? Drugs, alcohol?
Oh, that's a good for illegal drive.
Thank you.
All right, Your Honor, that's everybody. If you want to readdress number 25, Rachel Gilbert.
Yes. I thought we had Lang too, also, right? No.
Yeah, we do have one more language interpreter. Yes.
Okay. Rachel Gilbert. Okay. I've passed on your case, give you a chance to speak to your attorney. Have you had enough time to speak to your attorney about this case?
Yes, sir.
Okay. At this point, any argument as to the issue of probable cause?
Yes, Judge. I know the court already addressed Mr. Gray, and due to the conflict, I was chomping at the bit when it came to PC on the drug charges, because I believe on Ms. Gilbert, there would only be PC for count 1, the resisting without violence. As to the drug charges, the 923 does not indicate how the alleged drugs were identified or any field test positive or anything like that. So I think the 923 is lacking with sufficient facts to establish probable cause.
I believe the officers indicated that he identified these controlled substances as being that. Method of identification, I don't think it's probable cause standard. He located what he recognized or identified as cocaine, heroin, methamphetamines, amphetamines, ecstasy, cannabis, and alcohol.
But as far as the weights?
consider the charges.
Counsel for the state's suggesting I should look to the the charges as to the weight of the controlled substances.
I do see that as it relates to the weight, but identifying I think the first problem is the identification of the drugs as such. It doesn't indicate any information that how they identified it, what it was based on, or any field tests that were done.
Okay. If you like, I'm happy to give the state 24 hours to itemize that some more for you.
Yes, Judge.
But state.
Yeah, we'll contact you.
Okay. So at this point, Ms. Gilbert will be housed on no bond. We'll pass on this case till
I need to go home to my kids.
Okay. To address the issue of probable cause, your first appearance is postponed till May 24th at 9 o'clock to address the issue of probable cause. Thank you.
Great.
And then last is the interpreter.
And what about Ms. Lang?
Do we have Lang? Oh, that's the medical? Oh, can we put that that person after this person?
Sure. Mr. Basilio, we need to get a Portuguese interpreter.
I'm calling the language line now, Judge.
Thank you.
Welcome to Language Line Solutions. Please enter your 6-digit client ID. For Spanish, press 1. For other, press 2. Please speak the name of the desired language.
Portuguese.
I understood Portuguese. If this is correct, say yes or press 1. If this is incorrect, please enter the 5-digit extension number. Please hold for an interpreter. Please continue to hold for the next available interpreter. Please continue to hold for the next available interpreter. Please continue to hold for the next available interpreter. Please continue to hold for the next available interpreter. to hold for the next available interpreter. Please continue to hold for the next available interpreter. Please continue to hold for the next available interpreter. Please continue to hold for the next available interpreter.
Thank you for calling Language Line Solutions. This is Caroline, ID number 257098. I'll be a Portuguese interpreter today.
Good morning. I have you on a speakerphone here in open court. My name is Judge Garagoslo. Would you be kind enough to assist the court in translating from English to Portuguese and from Portuguese language back to the English language for the court?
Yes, Your Honor.
Would you please ask the gentleman standing before me his full name?
Senhor, você poderia me dizer o seu nome completo, por favor?
Josmar Ramos Basilio.
Josmar Ramos Basilio.
Mr. Basilio, you're here before the court charged with a felony crime. As to this charge, you're entitled to representation by a lawyer. I don't want you to say anything about the facts of the case. So the first question I need to ask you is, are you able to hire a lawyer, or should I appoint you an attorney today?
Senhor Basilio, você está sendo aqui acusado de um crime. Você tem direito de ser representado por um advogado. Eu não quero que você diga nada. Por enquanto, eu gostaria de saber, primeiramente, se você tem condições de arcar com as despesas de um advogado.
Não, senhora, tenho não.
No, Your Honor, no, I do not.
Would you like me to appoint you a court-appointed counsel today?
Você gostaria que nós lhe darmos um representante, um advogado hoje?
Mas eu não tenho condição para pagar, não.
But I don't have the means to pay for it.
Okay. Under our system, it would be a little no cost to you.
Perante o nosso sistema, terá pouco custo ou nenhum custo ao senhor.
Ok, então pode, se tiver, tá bom.
Okay, so if it's available, then that's good.
Okay. To my dear counsel, were you able to ascertain any information about his finances?
No, I wasn't.
Okay. Sir, how much do you earn per month?
Senhor, quanto você ganha por mês?
Quanto eu ganho por mês?
How much I make in a month?
Yes.
Sim.
Eu ganho na faixa de $1.500, $2.000.
I make around $1,500, $2,000.
All right. Any other source of income?
Ok, o senhor tem alguma outra fonte de renda?
Não.
Não.
Do you own any real property, any vehicles?
Você é dono de alguma propriedade? O senhor tem algum veículo?
Eu comprei um veículo agora, tem uns 30 dias, só que eu nem terminei de pagar ainda não. Eu di um pouco e fiquei devendo 3 parcelas de 500 ainda.
Yes, I just bought a vehicle recently. It has been about 30 days, but I haven't finished paying for the vehicle. I gave a little bit down, and I still have 3 more installments of $500.
I am going to go ahead to find him partially indigent, appoint the Office of Public Defender to represent his interests.
Então, eu irei apontar um defensor público para poder lhe representar nos seus direitos.
Probable cause is found as to the charge. Should I read the charge, counsel, or are you waiving the reading of the charge?
The court can read it.
Ms. Basilio, the charge involved here is sexual battery by someone in custodial authority over a person under the age of 18, but over the age of 12.
Your Honor, this is the interpreter speaking. Could you please repeat the charge?
Sure. Sexual battery by someone who has custodial authority over a alleged victim who's over the age of 12 years, but less than 18 years of age.
A sua acusação é de agressão sexual por uma pessoa que tem a custódia da pessoa de mais de 12 anos, mas menos de 18 anos de idade.
Como é que é?
Court date is June 23rd. Court date is June 23rd, 8 o'clock, before Judge Ingram via courthouse for arraignment.
Senhor, a sua leitura formal será no dia 23 de junho, às 8 da manhã, com o juiz Ingrid.
At this point, what says the state as to the bond?
Judge, based on limited information and what appears to be limited ties to the community, I'd ask that you set the bond at $50,000. No contact with the victim, no contact with minors.
The state attorney's recommendation is $50,000, no contact with the alleged victim, or no contact with any child under the age of 18. What says the defense?
I can have a moment, Judge.
Mm-hmm.
Judge, I would ask that the court leave the bond at $35,000. He has no known convictions, no prior failures to appear. And looking at the PTR sheet, he has a local address in Melbourne, and based on a prior arrest, it would appear that he's been here at least a year or close to a year, if not more.
I appreciate that. At this point, bond will be set at $50,000 cash surety, no contact with the alleged victim, and no contact with any child under the age of 18 unless that child's parent or guardian is present at all times.
Então, a fiança é de $50 mil, que não tenha contato com a vítima e que não tenha contato com nenhuma criança com menos de 18 anos, a não ser que o pai dessa criança esteja presente no momento.
Thank you, sir. You have a good afternoon, sir.
Obrigado, senhor. Tenha uma ótima tarde.
To our interpreter, thank you very much for your time.
Não.
This is the interpreter speaking. Your Honor, may I ask a repetition from the gentleman?
Yes, please.
Senhor, você poderia repetir, por favor?
Eu não entendi.
I didn't understand.
What is it that you didn't understand, sir?
O que é que o senhor não entendeu, senhor?
É aquele que falou de julho lá, no seu, lá de julho, vai ter em julho e negócio de $50 mil. Eu não entendi.
Something about July and something about $50,000. I didn't quite get it.
Your bond to get out of custody is $50,000 cash, or if you go through a bondsman, it's called surety. So you would have to come up with 10% down plus collateral. Your court date is scheduled that you must show up for arraignment on June 23rd via courthouse at 8 o'clock to address the case.
Senhor, a sua fiança é de $50 mil, a não ser que você vá por uma empresa de fiança, você tem que dar 10% deste valor, mais o colateral, e a sua leitura formal de acusações será feita no dia 23 de junho, nesta corte, às 8 da manhã.
Ok.
Any other questions, sir? Any other
Alguma
questions
outra
for the
pergunta,
court?
senhor?
Mas aí como é que eu faço para mim entrar em contato, para mim ver se eu consigo o dinheiro da fiança?
And what do I do to get a hold of somebody to see if I'm able to get the money for the bond?
They'll give you access to a telephone to contact the bail bonding agency, or you can contact your family.
Eles irão lhe dar acesso a um telefone para que você possa entrar em contato com a empresa de fiança ou para você entrar em contato com sua família.
Ok.
Ok.
Any other questions about the bond or court dates?
Alguma outra pergunta sobre a fiança ou a data para comparecer à corte?
Eu não entendo o que é esse negócio de corte que vocês falam.
I don't understand this about court that you're talking about.
Your attorney can explain that better at some point, but you must show up for your court appearance.
O seu advogado pode lhe explicar isso melhor, porém você precisa aparecer perante a corte.
Mas e qual que é o meu advogado?
And who's my attorney?
The office, a court-appointed counsel, a representative is here in jail court, and he's seated behind you.
Será nomeado para você, ele está, na verdade, ele está atrás do senhor aqui na corte agora.
Ah, tá.
Ok.
Ok.
Thank you, sir. You have a good afternoon.
Muito obrigado, senhor. Tenha uma boa tarde.
Obrigado.
Thank you.
Thank you to our court interpreter for your time this afternoon. You have a good afternoon. Ms. Lang?
All right, Ms. Lang will be coming in just a second.
I'm not hearing you say anything you want.
Ms. Lang, good afternoon. Can you hear me okay?
Yes, sir.
Can I please have your full name?
Carrie Lang.
Do you promise to tell the court the whole truth here this afternoon?
Yes,
To
sir.
help you God? Okay. Before the court, you hear charged with several offenses. I'm going to read these charges to you. You're charged with possession of a firearm by convicted felon, fourth offense DUI, battery on a police officer, 2 counts of resisting arrest. One is with violence, the other is without violence. 1 count of driving on a suspended license with knowledge, and 1 count of refusal to submit to a breath, blood, or urine test, having previously refused such a test. Ms. Lang, you're entitled to a lawyer. If you don't have the funds, I'm happy to appoint you a lawyer today. Are you planning on getting a private lawyer to help you with this, or should I appoint counsel for you?
I would like to get my own lawyer.
Very well. I'm going to respect your request and not appoint counsel for you today. At this point, I've had a chance to read this report. You should have a copy of the police report before you. The question I have for the state is this a fourth offense or should be a third with the previous convictions of 08 and this year? They all show a fourth?
Show 19 from Sebastian, 2019.
Okay, so.
There's a prior DUI 7, 8, and 19.
And this would be the fourth. Okay. Ms. Lang, at this point, please, I don't want you to say anything about the case because any statements you make about the case could be used against you. So just listen to what the state's recommending, and I'll hear from you as to the issue of bond. I do find probable cause for your arrest on 7 counts before me. Your court date is coming up on June 23rd, 8 o'clock before Judge Ingram, Viera Courthouse for arraignment. Right now, you're being housed on no bond on several of the charges. What says the state as to possession of firearm by convicted felon charge?
On that charge, I'd ask for $15,000.
And the fourth offense, DUI?
I'm just checking her driving record again, just to be sure.
Okay.
This is a third.
Third, it should be a third. That's what I thought.
So I have a citation for 402 for XDQ out of Indian River County. She was convicted of DUI. And then 402 for XDQ. Let's see, that's a bit. She has 2. There's 2 of them.
So this would be her third within 10 years. Right?
So I'd ask for $5,000.
5. Okay. Any objection to the other scheduled bonds?
No, sir.
Okay. Ms. Lang, count 2 should really be modified to a third offense within 10 years. It's still a felony charge. So you're on probation down in Vero Beach for a similar offense that you were placed on probation January this year. So at this point, bond on count 1 will be set at $15,000. Count 2, the charge is third offense DUI within 10 years. Bond is $5,000. Count 3, battery on a police officer is $5,000. Count 4, resisting arrest with violence. Bond is $5,000. Count 5, resisting arrest without violence is $500. Driving on a suspended license with knowledge, first offense, $500. And count 7, the refusal to submit to a breath test or urine test. After having refused such a test in the previous occasions, bond is $500. If you do post a bond, you're not permitted to operate any vehicles while this case is pending here in Brevard County. Any questions about what I said?
No.
I wish you the best, and you sure you don't want me to appoint you a lawyer? You plan on getting a private lawyer, right?
Correct.
All right. Thank you, Ms. Lang. Have a good afternoon. With that, is there any other cases before we conclude?
No, Your Honor, that's it.
Thank you all. I'm sorry about the delay today. You all have a good afternoon.
You too, Judge.
Thank you.